looking out at the chat to answer any questions that you might have, and also be answering questions during the Q&A portion. But I'll be doing the majority of the presentation today. I'm not sure if some of you attended the last presentation we did on COVID provisions that you could add to your parent-provider contracts. After that training, there was some questions about contracts in general. So today we wanted to go over a general training about contracts, the usefulness of them, how you can lay them out, and what provisions to have in order to best protect yourself from various standard things that might occur during your business practices. In the chat, I did put a link there. Let me pull it up really quickly. I'll go ahead and link it again. You can follow along with the sample contract that we have on our website. And that way you can refer to the different provisions that I'll be going over today. So first, just a quick disclaimer. This presentation is intended as a general overview of the issues involved in operating childcare businesses, and it's not intended to provide you with specific legal advice. This presentation should not be construed as all-inclusive, nor as the provision of legal services to any individual or entity. Attending this presentation does not create any lawyer-client relationship. So I'm going to be looking down a bit just to refer to some notes so I don't miss some of the stuff. So I apologize if I'm looking away from the screen, but we'll jump into some of the content. So first, Public Counsel's Early Care and Education Law Unit provides free legal services to qualifying child care providers in Los Angeles. Qualifying child care provider is one who provides, means either the providers who are low income themselves or who serve low income children. The focus is on improving the quality of care provided and increasing the quantity of child care facilities in Los Angeles County. So today's presentation, we're going to cover what is a contract, why does a child care provider need a contract, the explanation of important contract terms, and creating your own contracts and policies. So you want to remember two words that will be the theme of this presentation, and that includes protection and professionalism. Before we get into the substance, a quick word of warning: contracts involve a lot of legal jargon, but we'll explain a majority of it as best we can, and hopefully it can be understandable that way. Some of the things might be confusing, but we will reserve some time at the end for questions in case you want to ask any specific questions about your contracts or some of the topics here that might be a little confusing. So first, what is a contract? A contract is an agreement between two or more parties creating legal obligations. Verbal agreements are sufficient to form a contract, but having the agreement in writing helps if a dispute arises. So some more legal jargon. A contract is a binding promise. So basically you do something and I do something for you. So we're exchanging promises there. And contracts are all around us. We have all entered into contracts. Some common contracts that people might enter into include rental agreements, loans, contracts for tuition, different kinds of purchases that you might get, credit cards, different internet sites which have you click, agree to the terms there. And if you've ever been an employee, sometimes you enter into an employment contract. So what is a breach? You can breach a contract by failing to perform your own promise. Every breach gives rise to a claim for damages. So I mentioned that contracts are binding promises. The difference between a contract and a regular promise is that if I promise to, take you out to join you for dinner someday, and I break that promise, there's nothing that will happen if I break that promise. But if I have a contract, it's different than a promise. So contracts are not breakable. For example, you can default on a loan, you can stop making payments, you can refuse terms after you've started performing the contract, and you can do something in a way that the contract says you shouldn't. This is called a breach or a broken promise. Because they create legal obligations, you have legal remedies available for you. You can go to court, you can threaten to go to court, you can enter a collection process for payments. So basically a contract offers you protection. So this brings us back to our central question of why we are here, and why do you need a contract? A written contract makes everyone's life easier. Childcare is a business situation. It's a good business practice to have a contract. A contract creates clear evidence of expectations on both sides, and it's helpful as a tool to discuss all key program rules and policies. So basically, we go back to our two keywords of protection and professionalism. We talked a bit about the protection part, where you have protection if somebody breaks a promise under the contract. And also remember that you're a business. Contracts offer you protection to help ensure payments come on time. They protect your cash flow, and they ensure that people are following the rules of your childcare. Again, you're part of the childcare industry, so contracts are also a good business practice. In that sense, contracts spell out all your policies on one document. They give details of your program. They provide a record that you've conveyed the details to your clients, and they make it easier for you. So we'll go to a hypothetical here, just so you all can see the benefits of having a contract. So in scenario 1, the provider doesn't have a written contract, and a dispute arises between the provider and the parent. The child care fees are $800 per month, and the parent had verbally stated she wanted care every day on a monthly basis. However, the parent wants to pay $600 for care because the child only went to 3 weeks of child care that particular month. In scenario 2, what if we have the same situation as scenario 1, but now there's a contract which says the full fee will be charged for all absences. No refund, credit, or makeup day is provided for children who are absent for any reason. In scenario 1, how many of you think the provider is entitled to the full $800 even though there's no contract and the child got care only for 3 weeks out of 4? If you think that the provider is owed the full amount, maybe you can type in the chat that you agree that in this scenario, scenario 1, the provider is owed the full $800. And then in scenario 2, how many of you think the provider is entitled to the full $800? So it looks like folks are saying they agree for number 2, scenario 2, that the provider is owed the full $800. And so when the contract is in writing and clearly states that parents are responsible for paying the child care fees, even when the child is absent, all the expectations are clear up front, so there's less room for dispute, and the provider can easily refer to the written contract which was signed by parent if a dispute arises. So because of the contract, we've cleared up the terms, the parent is aware of what the terms are, and they're less likely to dispute you based on the fact that they've already been provided that information. And we have less room for disputes and discrepancy about what is owed. So in this situation, a contract is very helpful for determining things like payment, when payment should be made, how much payment should be made to the provider. So it's easier to clear up those kinds of situations. So some key contract terms include the name of the program, and these are all terms that you'll want to include in your contract. And if you look at the sample that I linked to in the chat, all of these terms will be in there. But it'll include name of the program, hours of operation, fees, absence policy, child illness policy, cancellation by the parent or provider, holiday, sick time and vacation, and duties to report child abuse, as well as guidelines for releasing children. We'll go over some of these provisions in further slides in a little bit more detail. Additional considerations includes waiver, modification, the agreement, and signatures. These are all more legal terms. In the sample, you'll be able to see some of the text that goes under these. But again, these are just good provisions to have in a contract generally. And they do include a little bit more legal jargon that might be confusing. So we're happy to answer any questions about those. So in the name of your program, you want to make sure you include the name of your program at the top of the first page of the contract. If the name of your program is not one that includes your own name, then make sure your personal name is on the contract elsewhere, clearly identifying you as a party to the contract. So whoever's licensed, their name should go on the contract unless you've been incorporated as an LLC or other kinds of business entity. That name should go on the contract. But if you haven't been incorporated, your own name should go on the contract as the party who's contracting between the parents. And then for the hours of operation section, you want to indicate the exact hours and days that you'll be caring for the children. I saw a question in the chat of whether you all can get the PowerPoint, and yes, we'll give it to Alyssa after this, so it can be forwarded to you all. We can also forward again the sample contract, so you can take a look at that as well. But again, so hours of operation, you want to indicate the exact hours and days that you'll be caring for the children. You want to balance your desire to get business by going beyond a standard workday versus meeting your own personal needs. This would include rules on drop-off and pickup times. And this last note here, where California law affords parents the right to visit the home anytime without advance notice, this is true, but you can also make some requests within your contract about COVID safety. So this includes like waiting outside and stuff like that, which we'll talk further about in a little bit. And so hours of operation are important to be clear about. And we'll go over this a little bit in the next, on the next slide as well under a hypothetical. But as a business, you have operating hours. So, you know, we don't want to let parents take advantage of you and come and go as they please. We want to be able to balance work life and home life. And for this reason, it's important to have standard hours of operation that you typically run your childcare business during. And it's also important to list your hours of operation because you can determine your fees based off of the different times of day that you're providing care for children. So next we have a hypothetical. So for example, Jenny is licensed to operate a large family childcare. This includes 12 children and runs her program from 6 a.m. to 6 p.m. A family signed a contract for childcare from 8 a.m. to 5 p.m. Monday through Friday. A few weeks later, happy with the service, the parents requested that their pickup time be changed to 5:45 p.m. and then 6:30 p.m. What might Jenny do in this situation? So if the parents want a pickup time changed to 5:45 and Jenny agrees to this, she should note this modification in writing and all parties should sign it on the contract. If parents want pickup time changed to 6:30, Jenny has to consider if she wants to change her business hours to accommodate this request. So 6:30 is after her childcare closes. She needs to decide if she wants to accommodate the request. On the one hand, it means getting paid slightly more for caring for the child for a longer time, but it also means Jenny has less personal time for herself and her family. Also, if other parents see Jenny staying open past 6 p.m. for this child, they may also request longer hours for their children, and it may get too burdensome for Jenny. If Jenny decides to care for the child until 6:30, she should note this modification in writing and all parties should sign it. So it might make best business sense to extend the time to provide longer care hours, but you want to make sure whether somebody is changing their time within your hours of operation or outside of those hours that you're marking or noting the modification on their contract and making sure that both parties have that information and understand if there's any extra fees associated with that extra coverage of time as well. So that brings us to fees. Under this section, you'll want to lay out very clearly all the fees because payment problems are one of the most common issues faced by childcare providers. So it's important that you specify what your rate is and when the fee is due. And for assistance in determining your fee, you can contact your local resource and referral agency and see what average rates are charged. And we will discuss payment problems more specifically towards the end of the presentation. So for example, if someone doesn't pay on time, but we want to make sure that our business is successful. So we want to make sure that the fees are clearly laid out. It's clear for parents how much they owe. And it's also important that we charge everybody the same rate and make any discounts that we provide to parents available to all. So in that sense, we want to make sure that we're not providing special discounts to folks, to different people, that people are getting paid the same amount for the same types of fees that are applying and for the same hours of coverage that they're being provided childcare as well. So under a payment schedule, you should specify when payment is due. Indicate whether you will require a weekly, bi-weekly, or monthly payment and exactly what day you expect payment, and decide whether you will require advance payment to avoid having to recover payment for past services. We recommend requiring payment the Friday prior to the week that care will be provided. So advance payment is usually helpful so that you're not running into any issues after providing care and chasing down payment for care for previous care provided. So for part-time care, if you provide both full and part-time care, list them separately. Specify important program policies related to part-time care. So for example, whether you allow a parent to substitute one day for another, whether you require advance notice for substitutions, etc. You want to make sure that if you provide part-time care, because there's some flexibility in there, that you're clear about what days care is being provided. And then additionally, in under fees, you can include some potentially refundable fees. So this will be an enrollment fee and a deposit. We recommend that providers charge a refundable deposit, sometimes equal to 2 weeks worth of care. This way, if a parent withdraws their child from your program and owes you any childcare fee, you can use a deposit to cover those fees. Deposits have to be refundable, so talk about those with the parents, what they're for and what they're not, and then collect them up front when enrolling a student. So for example, collecting deposit in payments instead of all up front can create problems. And the deposit is there to protect you if a parent leaves the program early. It's like a rental deposit that we pay when we rent any kind of apartment or home. If we damage the home, then the landlord can keep the deposit to make up for any payment. So similarly, if the parent pulls their child out of the program early, you can keep the deposit funds to cover any previously provided childcare that they haven't paid for yet if they don't end up paying you for those services. But if they have paid you fully for the childcare that was provided to them, then the deposit will be refundable to them. Additional charges, you'll want to include, or you can include a provision about whether a fee will be charged for late pickup or early drop off. So again, we go back to the hours of operation that we mentioned earlier. If parents are dropping their children off early before their time that they're supposed to, or picking them up late after the time that they were supposed to, you can charge a certain amount per 15 or 30 minutes that they're late. You can also include whether there's a penalty for late fee payments. So if they pay their childcare fees late, you can charge a penalty fee. And you can also indicate whether late payment of fees numerous times is ground for terminating the contract. And we'll talk more about termination in further slides as well. So let's jump to a hypothetical. Susie's child is enrolled in Smith's family childcare, and Susie recently lost her job. Ms. Smith, realizing that Susie is down on her luck, tells Susie that she only needs to pay 50% of the childcare fees that she agreed to pay until she gets a new job. Is this permitted? Feel free to chime in the chat. So I see a lot of no's coming in. And that's correct. Although you might think that Susie's being nice and her motivations are good, other people who aren't receiving this discount might come up with might come up to Susie and request the discount, and she's not giving it to everybody. She's not applying it to every child the same, and so she could be accused of some form of discrimination if she's applying it to one person or two people and not to everybody. And it's better to apply the same rules to everybody. So if you have a contract and the contract states the fee, you'll want to make sure that you're enforcing the fee the same for everybody. Sometimes it might be difficult when people come to you asking for a reduction in their fee, but you should stick to the contract. If you find that most of your clients aren't able to meet the fee, you might want to reevaluate the contract and adjust the fee for everybody if that seems like it would work. But otherwise, you want to apply the same things for all the children in your program. So again, it's recommended that the provider not give any discounts or make exceptions to the rules in the contract, unless the same discounts or exceptions are applied to everybody. So include any available discounts in the contract and for what circumstances they will apply for. Discounts must be based on objective criteria such as educational background of child's parents, sibling discount, child of a single parent, or child whose family resides in a certain low-income geographic area. So in this way, you're being clear about which discounts and exceptions you're applying, and you're applying them equally to everybody. Anybody who falls into those categories can apply for the discount as well. Also remember, you can't charge private paying families less than subsidy programs simply because private paying families are paying the fees themselves. I think Ritu can answer some more questions about that if there are any that pop up. Next, we'll jump to the absence policy. So payment for absences. Most providers require parents to pay the full fee when their child is absent, whether the child is ill or on vacation. The reason for the full fee is that parents pay for the space in the childcare whether or not they use it on a given day. So ask parents to provide reasonable notice of absences. So why have an absence policy? It's basically like having something such as a gym membership. You have to pay whether or not you go. Notice gives you time to prepare, and if they give you notice, they might not have to pay, but it should be included in your contract what will happen. So typically, we do suggest that that providers request payment if children are absent. If you have a notice provision in your contract and they provide reasonable notice, you could include that the parent doesn't have to pay for the absence, but it's up to you how you include that in your contract. Somebody asked about tuition due when the center is closed due to COVID, and we're going to talk about that in some later slides, and it should be included in the contract as well. So you should also include a child illness policy. You must protect all children in your care from illness whenever possible. Parents need to know that you may not be able to accept a child if they are sick, or that you may send the child home if they become sick. Consider including an additional fee in your contract for isolated care if a parent cannot pick up a sick child. So some things that you might want to include in your contract for when a child should be sent home include having a fever over 101 degrees, vomiting, skin rash, constant cough, upset stomach, parasites, communicable diseases, and so on. It's a state licensing requirement that we try to contain infectious diseases. So you want to make sure that your provision states what you will do in case somebody shows up with these symptoms. And if you discover that a child is sick after the parent drops them off, you want to try and protect the other children. So we'll go over that in the next couple of slides. Sometimes when we call a parent to come pick up a child, they might not be available right away. So that's where we talk about the isolated care. You can charge a fee if you have to isolate a child in your program, maybe take them away from the group and put them in a separate room where they'll be receiving more care. You can potentially put in your contract that you will charge an extra fee for that care. And again, you'll want to include a COVID-19 illness policy specifically. In our sample contract, there is some text there for that as well. Having a COVID-19 illness policy is helpful for protecting you, your staff, and children in the program. You can include specific requirements informed by public health guidelines for when a child is exposed or becomes ill with COVID-19. And having this kind of provision allows you to terminate care or make adjustments as needed. Again, the different kinds of symptoms that you might experience with a child that has COVID-19, if they present with those, you can take the same course of action for other illnesses, isolate the child, ask for their parents to pick them up early, or charge extra fee for isolated care. So if a parent wants to cancel their care, most providers require a 2-week written notice before a parent withdraws their child from the program. Your contract should include a provision requiring the parent to pay for 2 weeks of care if notice is not given. And we recommend that you require a deposit that is equal to the amount of time you're asking people to give you notice of termination. So if you're asking parents to provide 2 weeks notice of termination, then your deposit we recommend should be equivalent to 2 weeks. So in case they don't give you that notice, then you can require them to pay for the 2 weeks of care. And if you've ever had a parent tell you unexpectedly that a child is withdrawing from your program, you'll have experience with this. It's important to protect yourself in your contract because this could happen if it hasn't already. This is where the deposit that we talked about earlier comes into play. You should make sure to ask for the deposit up front. And if a parent ever withdraws her child from the program and refuses to pay, the deposit can protect you so that you don't lose the money you should have received. So you as a provider can also cancel care for a child. It's important that you reserve the right to cancel the contract. If you require a 2-week notice from parents out of courtesy, you should also give parents a 2 weeks notice of cancellation. Make sure that you give the parent written notification of your intention to terminate a contract so that the parent has notice as well as an opportunity to correct the problem causing you to terminate. So if the cancellation is due to a problem with providing them care, you might want to provide the parent some opportunity to correct so that you can maintain that client and so that you can continue to provide care for the child. So we'll jump into another hypothetical. Johnny Jr. has turned 2 years old, and with the terrible twos came some terrible behavior. Not only is he loud and disobeys all instruction, but today he bit another child. Can anybody share what might be the provider's options in this situation? You can unmute yourself if you feel comfortable doing so. Well, I can share that in this situation, sorry, we have something in the chat, sorry. Yeah, so you can have a biting policy that outlines how you deal with biting in the contract. You can, suggest cancellation as a provider and give the parent 2 weeks notice. If you want them to see if they can correct the behavior, you can let them know and see if it corrects and then continue care for them. And this also brings us to our next slide for immediate termination by provider. So it's important that you also reserve the right to immediate termination without notice in certain circumstances. You should separately list the conditions under which enrollment may be terminated immediately. So for example, failure to pay, failure to pick up a child, failure to follow COVID-19 rules, and those under which notice will be given. And there's one situation where you can reserve a contractual right to immediately terminate your contract with a parent. This includes when the child or parent's behavior poses a significant threat to the physical or mental well-being of one or more children, and you're unable to immediately eliminate the threat in a way other than to ask the child or parent not to continue using your services. So if we go back to the previous hypothetical, if the child is biting another child, then this would fall under immediate termination by provider and would allow you to not necessarily provide the 2 week notice, but to immediately terminate your care to that child. So again, if the child or parent's behavior is posing a significant threat to you or other children in the program, you can immediately terminate. And you should have this kind of provision included in your contract for these certain situations. And this is also important during COVID-19 practices, because if a parent or a child fails to follow your COVID-19 rules, you can include that in the contract that you'll be able to terminate immediately in order to protect yourself, your staff, and other children coming to the program from contracting COVID-19. So in your contract, you'll also want to include provisions for holidays and vacation time. List in the contract all the holidays that you'll not be providing childcare for. Indicate in the contract that you reserve certain days for vacation time. So if you don't know ahead of time which days you want to take vacation, you can indicate that you'll take a certain amount of time. And it's up to you whether or not you want to be paid for your vacation time. So in some contracts, providers will request 2 weeks of paid vacation per year, where parents are still paying for services. And some providers will request unpaid vacation, and it's really up to you and your business practice. So remember that you're a business, you're charging parents for their child's enrollment. You're not charging them a day-to-day fee. So you're permitted not to offer services on certain days, as long as you list these days in your contract and give notice to the parents. you'll want to at least give some advance notice of your vacation. We suggest a minimum of 4 weeks so that parent has time to make other arrangements for their child while you're not providing care and you're on vacation. But otherwise, you should feel comfortable taking some vacation days during the year while still potentially requesting payment for those days. So I know we had a question earlier about closures due to COVID-19. In the sample contract, you'll see a section about closures due to COVID-19. So it's possible that you might need to close your childcare beyond the holidays and vacations you listed, including for anything arising out of an emergency situation or something including the pandemic. But you want to have a policy for unforeseen circumstances, including the pandemic, public health emergencies, or natural disasters. And having such a thing will prepare the parents for these kinds of situations. You can also specify that refunds will not be made in these types of emergency circumstances. So in this case, because they're unforeseen circumstances, you're not necessarily expected to provide a refund, and you can include in your contract that due to these kinds of closures, you might have to close, but you will also not be providing a refund in those situations. So similar to the vacation time, you want to make sure that you reserve sick time or personal days in case you or a loved one requires medical attention. Make sure there's a pro rata reimbursement clause for parents if you go over the days allotted in the contract. So that there's a sample provision in the contract. But if for some reason you go over the time that you've required for sick time or personal days, you can reimburse parents for that time that they're not provided care. So then we jump into guidelines for releasing children. It's important that parents are aware that you will only release their child to the child's legal parents or legal guardians or to persons specifically authorized in writing in advance by parents. Difficulties may arise when parents are separated or divorced. Providers can only comply with court orders, for example, custody or restraining orders that are current, signed by a judge or officer of the court, and which they have a copy of. So you should keep in mind that sometimes even when you have certain individuals listed by the child's parents as authorized pickup people, you might encounter some obstacles. With children whose parents have separated or divorced, you might encounter the problem of the parent's new partner trying to come pick up the child. You must notify the parent that unless the parent lists his or her new partner as an authorized pickup person, you cannot legally release the child to the individual. You should also include a provision in your contract about court orders and restraining orders, and make sure that they're valid and they have a current valid copy of them. In addition to this, you can adjust your drop-off and pickup procedures to provide some extra security and prevent the spread of COVID-19. So you can ask parents to follow certain procedures. This may include requirements such as wearing a mask when dropping off or picking up their child, bringing their own pen to sign their child in and out, maintaining physical distance, not entering your home, waiting outside to pick up or drop off the children and having somebody meet them outside. So you can include these kinds of things based on public health recommendations. There is a sample provision of this in the sample contract as well. Additionally, you want to include a duty to report abuse provision. So licensed child care providers and staff are mandated child abuse reporters. Licensing provides a form that you are required to give to parents. You want to notify parents of your responsibility to report child abuse by including it in your contract. Large penalties for not reporting include 6 months in jail or a $1,000 fine or both. So if you know or reasonably suspect that a child you're taking care of has been the victim of abuse, whether physical or psychological, you're required by law to report this information to a child protective agency. You'll want to include a clause in here so that parents are aware of this and that you clearly outline your responsibilities. That way you are just putting them on notice that that's a requirement that you have to follow. Some additional considerations to include in the contract can include a discipline policy, fee for placement on the waiting list, policy on prescription medications, and immunization requirements. Again, there are samples of those kinds of provisions in the contract as well, so you can take a look at those. The contract is customizable, so you want to make sure that some of these things, that all these things in the contract apply to your child care program, and are specific to the practices that you're going to be implementing. So for modification or amendment of the contract, you want to retain the right to modify or amend your agreement with the parents by including a modification or amendment clause in your contract. It's good practice to make any changes apply to all contracts. So when you change a contract, you want to not change it for just one parent, but you want to occasionally reevaluate your contract, make sure that it applies to your program and you're still using the practices that you indicate in it. And any changes that you do make or update, for example, if you are going to update your contract with COVID-19 specific policies, any changes that you make, you want to apply to all parents and to provide a new contract to all clients of yours and receive a signed copy back from them. So in the next few slides, we'll go over some more dry contract provisions. You should always include this in your contract, and not doing so will include some important legal consequences. So including these provisions is for your own protection, including this modification and amendment provision, and they help you prevent from any kind of unnecessary legal action. So an entire agreement provision will prevent either party from asserting that at the time the contract was entered into, the other party made verbal or other written representation that somehow altered the written obligations of the parties. In other words, it means that the contract that was signed by the parents and provider constitutes the entire agreement. Everything you agree to is right there, written down in your contract, and anything that you might have, written otherwise doesn't apply, but what's in the contract applies. And so you want to make sure that this provision is in there so that if there's any kinds of misunderstandings or they thought that you said something else another time, that you can refer to the contract as the full agreement that you've made with them. You'll also want to include an invalid provision statement. The statement means that if for some reason a court finds any provisions of the contract to be legally unenforceable, the rest of the contract will still be enforced. So if you take a dispute, if you have to take a dispute before a judge and the judge says that you can't enforce part of your contract, for example, the paragraph on vacations, the rest of the contract is still enforceable. So this basically says, if some part of the contract doesn't work out, the rest of it still applies. You'll also want to include a provision on waiver. A waiver clause puts the parents on notice that even if the provider does not always enforce all provisions in the contract, for example, if you allow a parent to once in a while pick up a child late without paying late fees, the provider still retains the right to enforce all of the provisions of the contract. However, we recommend that providers always enforce all provisions in their contract and not make exceptions for certain families, because a judge could interpret consistent failure to enforce certain contract provisions as evidence that parent was not required to comply with those provisions. And so even though you might have this in your contract, a judge could say otherwise, that you should have enforced the provisions more consistently. But you want to make sure that you have this to protect against some of those discrepancies. So you also want to include a governing law provision. A governing law provision ensures that California law will govern any dispute over the parent-provider contract, even if, for example, a parent later moves to another state. So it's important because if a parent moves to another state after you have a dispute with them, you want to be able to have California law apply to your contract and not the law of some other state. And last but not least, for the provisions, you want to include signatures. It's very important that the parents have an opportunity to read the contract carefully before signing it. You should always try to get both parents to sign the contract, regardless of whether the parents are separated, divorced, or have never been married. Both you and the parent should have a copy of the signed contract, but you should keep the original. It may be worthwhile to have the parent initial next to each clause or after each page as well. Initials can be helpful, but ultimately you want to make sure that they signed the contract on the last page, or the signature portion is, to indicate that they have read through the contract and agreed to the terms in the contract. Again, each provider is different. Each childcare program is different, and you want to make sure that your contract that you create meets the needs of your specific program. Our sample contract is just a sample. It includes all the provisions that we talked about and some ways that you can organize your contract. It may not fit your program, so you want to make sure that you're reading through it, highlighting the parts that might not work for you and adjusting the language to work for your program. You might want to consider asking a lawyer to review your contract before using with any parents. And that's where really public counsel comes in. And so if you qualify for our services, we're available to help you tailor your contract to your program and adjust it so that it makes sense for your program. We're available for that and are happy to answer any questions you might have about the contract as well. Parents of every child in your care should sign the same basic contract. If you're already providing care without a written contract, you should ask current parents to sign a contract and use the same one with new parents. And if you have any questions, again, Public Counsel is a great resource. I'm going to link to our sample contract again, but I also want to, I can't actually access the web, but I'll link to the sample contract again. And then after I close this presentation, I'll link to our general page where you can find more resources there. So in order to do a client with, an intake with Public Counsel, you can call this number here at the bottom, 213-385-2977, extension 300. And you can also email myself or Ritu to follow up. I'll put our emails here in the chat. We might send you a link to do an intake via an online form. But for now, you can call the number as well if you want to do an intake there. So that concludes the overview of contracts. I want to take some time to answer questions. If you have specific questions about your contract or general questions about contracts, and you can go ahead and ask them in the chat, or you can also unmute yourself and ask them. And so Ritu and I can answer any questions that you might have. I'm going to stop sharing my screen just so that we can see everybody. And if you want to raise your hand, if you have any questions, that might be helpful as well. Or if you want to unmute yourself, you can go ahead and ask as well.
I have a question.
Go ahead.
Yeah. I don't know if you said it in the beginning, but can you clarify what is the difference between the policies and the contract?
Risha, did you want to go ahead and?
Yeah, so like a lot of smaller providers will have just a parent-provider contract, which contains, the terms we talked about in today's trainings. Many of those are policies, but they're in the contract. Some providers who have a bigger program might have a contract and also a handbook, but a lot of the clients we serve just end up having one document because the handbook tends to be like other policies, like let's say about how to celebrate birthdays or field trips, or what happens if there's an emergency, or like talking about meals. So it's like policies that are important to the program, but they're not necessarily important to have in your contract. But if you're like a newer program or a smaller program or a program that doesn't have like too many details to it, it's fine to just have one document, which is the contract, which has all the types of things we talked about today.
Okay. And then another question, can you have a contract stating that a parent would adhere to everything that's in the policies?
Yeah, so your contract will, you'll have a section saying like at the end, by signing this contract, the parent is agreeing to abide by the provider's policies mentioned in this contract, as well as, other policies. But it's better to have all of the, if you're having someone sign something like that, it's better to have all of it in one document if possible, or have them, if it's in another if it's in several documents, have them sign something for each document. Does that make sense?
Yeah.
So like, for example, for you, how many documents do you have parents sign that contain policies?
Oh, I'm not a childcare provider.
Okay. So I guess what situation are you thinking of?
I was just thinking of how in the policies, just like you said, there's a lot of things of like, I don't know, bring in extra clothes, how you
Uh-huh.
celebrate birthday,
Yeah.
all of those things. So
Yeah.
for my
So,
thing would be just write it out in the policies and then have
yeah.
a contract saying that you adhere to those. In the policies, you can also write, for instance, what are your hours,
Yeah. Yeah.
all that stuff, and just have it and just have a separate document where they can just sign it.
Yeah, I think that's fine. It's just like for us, we think of the contract as having like your hours, the fees, some of your policies. If you want, it can have all of your policies, depending on how many your program has. And then at the end, the parent signs it saying, I agree that I've read this document and that I'm going to abide by all of the provider's policies. And if they don't, you can use that as a reason to terminate childcare.
Okay, then thank you.
Sure.
Are there any other questions or anybody who asked the question in the chat that wanted to clarify or didn't get an answer for their question?
Yeah, we've taken a lot of time to develop these sample contracts that are on our website, which we've linked to. One of them is just like a normal contract pre-COVID, and one is a contract that has COVID provisions in it. So, definitely check those out. They should be really helpful. A lot of people use our sample contract. I think a lot of the R&Rs use it with the providers that they work with. So it has like the provisions that over time we've seen to be the most useful in these documents. And I think COVID really highlighted how your contract needs to be really clear and sort of anticipate these unforeseen type of situations. So that's why going forward, I think it's good for providers to have something in their contract about like, if I do have to close, due to some unforeseen situation, what's going to happen in terms of tuition and the money that parents have already paid and money going forward to hold the child spot in the daycare. And it is like an individual business decision, but whatever you decide should be very clear in your contract or policies.
Right.
And if
There's no,
yeah,
go ahead.
I was just going to say, if someone is not sure if they qualify for our services, they can definitely fill out our online application and we'll get back to you. But we do help people create their own contracts or update their current contracts.
Sorry, I have another question. If nobody else has any other one. But I was wondering, how many times a year do you recommend that a provider goes over the contract again with parents?
I mean, you don't have obviously when a child's being enrolled, it's good to go over it, have parents maybe sign, initial each paragraph, explain it to them. If you update it, I would do the same thing at the time of updating it. But other than that, you really don't have to. Although I just know for my own son's preschool, sometimes they send us reminders through email about certain things that maybe they're feeling that parents aren't following certain things. So they'll just say like reminder, so that's an option too.
Josie, did you want to ask your question? I know you messaged it directly to me. Is that a question that you just wanted for me to answer to you, or do you want to ask it for the group? I'll go ahead and answer it through the text, through the chat. Okay, so Ritu, I don't know if you're seeing the chat, but just yes, can contracts apply to license exempt providers?
Yes, license exempt providers can have contracts too. Because even if you don't have a license, you're still running a daycare program and you can have a contract.
I have a question. There is a difference between a regular contract. If you just work by yourself, what about if you're a corporation?
Ritu, did you want to take that one? I'm not sure. I think Ritu might have stepped out. But if you're a corporation, you just want to make sure that for the contract, when you're setting on the first page who the contract is between, it's going to be between the corporation and the client. So you'll make sure that you're not putting you as an individual, because if you are incorporated either as a corporation or an LLC, the contract is essentially between you and between the corporation and the LLC, or the LLC and the client, not between you and the client. If that makes sense.
Yeah, thank you.
Right. Mm-hmm. And then Irene, I'm not sure how to answer this question, so I'm going to pass it along to Ritu, and then I can get back to you when I figure out some more information. So I think if people don't have any further questions, we want to make sure people get out of here on time. But there is some time for, one more question or so if anybody has anything.
Hi, my question was about agencies that pay us vendors directly, like Lanterman Regional Center and the CCRC. How do we make up that contract for the parent? Because they aren't paying us directly. Does that make sense? But they
Yes,
still
that
have
makes
to
sense.
they still have to abide by all the other rules, right?
Mm-hmm. Yeah, I think I will get back to you. I think Ritu probably knows best practices for that, and it seems like she stepped away for a minute, so I apologize, but we'll get back to you on that.
This was an awesome presentation. Thank you so much. We needed it.
Thank you. And again, we're here as a resource. So feel free to fill out the JOT form if you have, services that we can provide you, but also if you have questions, you can go ahead and email me and I'll see if I can answer those to the best of my ability. If you want to create a contract that's tailored towards your program, you can use a sample contract or you can reach out to us and we can assist you with that.
All right. Thank you, everybody, so much. The questions were great. The information was amazing. And so, as Dee said, we'll put all of the links that they shared today in the resources folder that went with this training on QSLA Connect. And we'll get the PowerPoint as well to support. Jana's going to put the evaluation link in the chat while you're here and thinking about it. If you would go ahead and fill that out for us. And then you can disregard it when you get it in your completion email tomorrow. We'd really appreciate it. We want to thank our partners at Public Counsel again. This is fantastic. We are recording it, so someday we'll get it back up on our YouTube channel so you can share with other people that you think might really benefit from this terrific information. And with that, we will let you get on with your evening. Thank you so much for being here tonight. We really appreciate it.
Thanks so much, everybody. Thank you.
All right, thank you.